Good afternoon. Welcome to today's hearing. My name is Councillor Kelly and I'll be chairing today's subcommittee hearing. My colleagues are Councillor Anand and Councillor Sumner, and we comprise the subcommittee. Hatun Zeb is legal advisor to the subcommittee, and also present is Cornelia Hardin, who is the clerk to the subcommittee and will be minuting the meeting. In accordance with procedure, I shall invite the police to present the application for a review hearing and call any witnesses in respect of whom permission to appear has been given and answer any questions put to them. Then I'll invite the premises to make their representations and answer any questions. And then I'll invite the parties to briefly sum up their respective cases. At the end of the meeting, the subcommittee, accompanied by the legal advisor and the committee clerk, will retire to consider its decision. The decision will be given at the end of the meeting and confirmed in writing within 5 working days. Excuse me. Furthermore, we have a number of people in the room. If I haven't mentioned your names, could you just introduce yourselves and anybody else that's with you, and obviously your relationship to this hearing. So maybe we'll start with Mr. Panchal. You're muted, Mr. Panchal. I had £1 for every time I said that. Not with you, just generally. Thank you.
Okay, sorry. I'm Mr. Panchal, representing the client, Mr. Kushal of Terrace Lounge, and I've got a legal representative, Mr. Leo, who is going to be representing us legally.
Okay, so that's
So good afternoon, Leo Cheryl MBD's counsel for the Terrace Lounge.
Thank you.
Thank you.
Miss Oliver.
Good afternoon. My name's Heather Oliver. I'm instructed by the Metropolitan Police Service. I'm assisted by PC Kerry Smart, the officer in this case.
And PC Smart, you're here as well.
Good afternoon, Chair. Yep, PC Kerry Smart, Police Licensing Officer.
And you're another officer is here, I believe.
Yeah, PC Ian Charwood from Perivale Safer Neighbourhoods team.
Okay, I believe that's everybody. So, police, Heather, if you'd like to present, please.
Thank you very much, Chair. It was in the early hours of the 25th of April of this year that a serious assault took place outside this premises, the Terrace Lounge. As you will have seen from the papers that have been submitted, the victim of that assault suffered a single punch in the course of a relatively brief altercation with another male. He was knocked unconscious, and we now know that he has suffered significant brain damage. At the time of the last hearing, he was in an induced coma, but that position has become clearer over the course of the last weeks. The investigation into that trigger event is ongoing. No charging decision has yet been made. As a result of that event and its connection to this premises, the summary review process under the 2003 Act was triggered. A superintendent signed the requisite certificate under section 53A, confirming that in his opinion, the premises were associated with serious crime. You will know, sir, that on the 30th of April, there was an expedited review, and you and your colleagues decided to suspend the licence for the premises under your powers, under your interim step powers under section 53B. We now come to the full review of the premises under section 53C. You will see from paragraph 5 of my written submissions the powers that are open to you, and no doubt you will be well familiar with them. As a result of having submitted those written submissions, I hope I can take matters relatively shortly this afternoon, although of course if you do need me to go into any further detail, I will. I don't imagine it to be in dispute that what happened on the 25th of April constitutes a serious crime within the meaning of section 81 of the Regulation of Investigatory Powers Act. At the interim steps hearing, argument focused on whether the premises could be said to be associated with that serious crime rather than whether the events constituted a serious crime. Well, in my submission, the circumstances do make out that connection and that association. The significant hallmarks of what happened on the 24th and 25th of April are as follows. Within minutes of leaving the premises, the victim of the offence suffered the assault. That assault occurred in the direct vicinity of the premises. It's outside Venus Motors, which you will have seen from the 4 initial clips of CCTV. Is directly next door to the premises. We know from analysis of CCTV footage and from witness testimony that the victim had been in the premises for several hours prior to that assault taking place. We now believe that he entered the premises around 10:20 in the evening. Previously, it was estimated between 9:30 and 10:30. He had been drinking in the premises with a Mr. Jitesh Halai. At the interim steps hearing, Mr. Halai attended and described himself as an investor in the premises. You will have seen from the crime reports and other documentation that he's variously described as a manager or the business partner of the designated premises supervisor and license holder, Mr. Kushal Shah. He certainly has a connection with the premises. Both the victim and Mr. Halai had been drinking to a degree of significant intoxication over the hours that they had spent at the Terrace Lounge. You will have seen from the CCTV footage that covers the stairs, the external stairs outside the premises, that both men, but certainly the victim, appeared to be unsteady on their feet as they left the premises. The alcohol that they had consumed constituted a bottle of Jägermeister and a bottle of raspberry vodka, according to what Mr. Halai told police. We also know from the further CCTV inquiries that have been undertaken by PC Smart that both men appear to have also been drinking beer from the premises earlier on. The bulk of that alcohol, though, appears to have been purchased for their consumption by Mr. Kushal Shah. You were shown a Tesco receipt at the last hearing. I believe my notes say that it was timed at 22:04. Certainly we see Mr. Shah entering the bar area with Tesco bags a short time later. And it's believed that he purchased that alcohol at Tesco and brought it back to the premises for consumption by Mr. Halai and the victim of the assault. There's also, you will have seen from the statement of PC Smart, some association, though I accept it's relatively tenuous, between the suspect involved in the assault and his, we assume girlfriend, but female friend who was with him in his vehicle. They appear to have attended the vicinity of the premises in the suspect's car, taken some shisha purchased from nearby, we believe, and indeed the female friend of the suspect enters the premises, the Terrace Lounge, appears to use the facilities and collect some hot drinks, and is inside the premises while the assault is taking place before she exits. CCTV inquiries have also revealed that security guards associated with the Terrace Lounge were on scene where the assault took place very quickly. They come over to where the assault has taken place. We believe that one security guard even made the 999 call. Subsequently, however, their cooperation with the investigation has not been particularly adequate. They have refused to make MG11 statements. And indeed, that's reflected in the ability of Mr. Halai to really give very much assistance to the investigation, because he has admitted he has no recollection due to the alcohol that he had taken post 11 p.m. You will have seen from paragraph 13 of my submissions and also paragraph 30 of PC Smart's statement that Mr. Kushal Shah is, I believe, accepted to have told a lie to police in relation to the victim's association with the premises. When he was contacted by PC Smart on the 26th of April, he told her that the premises were not open to the public, save for being open for a takeaway service of hot food only and not selling any alcohol. He stated that the victim had attended the premises to order food only. He explained that the victim had walked upstairs, ordered and paid for his food, and then walked back down the stairs where he waited in the street for his food. We know from the CCTV inquiries that that is not correct, not only in relation to the victim's attendance at the premises, but also in terms of the services that were being offered by the premises at the time at which it was open. So that in a nutshell is a relevant summary, I hope, of what happened in relation to this assault and why we say that that is associated with the premises. Attendant upon that, it became clear as a result of the investigation that the premises was operating, we say, in breach of the COVID regulations that were then in force. You will know that from the 12th of April of this year, hospitality venues were allowed to open, but only insofar as they were serving people outdoors, if that was a table service, and the rule of 6 applied. If a premises was substantially enclosed, then they were not allowed to serve alcohol or to serve food and drink to consumers inside. You will have seen the opinion expressed by Mary McLaughlin and an environmental health officer that this was a premises that was substantially enclosed because it had a roof and because the requisite openings of doors and windows were not such as to take it outside of that definition. And she communicated that view to Mr. Shah, and in fact was given assurances by Mr. Shah that he would not open in those circumstances, although it may be that he didn't agree with that assessment by environmental health. And indeed, Mr. Shah told PC Smart that he was not open for anything other than takeaway food when he spoke to her on the 26th of April. At the interim steps hearing, that was acknowledged to be incorrect. While it was maintained that perhaps the majority of patrons were in attendance for takeaway only, it was accepted that some patrons were sitting down and eating food and drinking alcohol. We know that that must be correct because you now have 3 further clips of CCTV footage in addition to the 4 that were provided previously. One from 1929 to 1951 in the evening showing the lounge area, and then 2 from behind the bar, the first from 22:23 to 22:47 and the second from 23:40 to 7 minutes past midnight. Those show a steady flow of food and drink to seated customers being paid for at the cash point, and you also have a till receipt that was provided by Mr. Shah demonstrating that alcohol and food were being served that evening. Hallmarks from that additional CCTV, which perhaps bear more on the trigger on the trigger event of the assault. As I've mentioned, PC Smart describes both the victim and Mr. Halai getting beer from behind the bar. At 22:29, a large container is filled with alcohol by Mr. Halai that is taken back into the lounge area and shared not only with the ultimate victim of the assault, but also with what PC Smart has described as Group 1, which is a group of other patrons in the premises. And there is smoking taking place by the victim, which goes unchallenged. And just a general, you may feel, disregard for any form of social distancing between the parties that are, we say, clearly becoming increasingly intoxicated during the hours that they spend at the premises. You also have in the statement of PC Smart an outline of the history of this premises, which demonstrates through a variety of intelligence reports, CADs and CRIS reports, which are all appended, a relatively regular degree of complaints about antisocial behaviour and indeed breach of COVID restrictions. You may feel, and we would assert, that the majority of the problems revealed by the statement of PC Smart centre around the suitability of Mr. Shah as a designated premises supervisor and his ability to properly uphold the licensing objectives, not only as demonstrated by the events of the 24th and 25th of April, but more generally. And so your focus may well be on whether it is appropriate for him to remain as designated premises supervisor. But he's also the licence holder, and you will have seen the view of PC Smart expressed that really the problems revealed by April are significant enough for you to be seriously considering revoking this licence at this review. Unless I can assist you any further, those were the submissions that I sought to make at this stage.
Thank you. Sorry. Miss Oliver. At this point, we normally call witnesses on your side. Would you like to do so at the moment?
Well, I have PC Smart here. She has given an extremely comprehensive witness statement in this case, so I don't intend to ask her any questions, but she is here for questions from the premises licence holder premises if they would like to.
It'll come up in the V further down. Questions from council, the premises council to Miss Oliver?
Sir, thank you. Not at this stage, no.
Okay. Councillors, any questions to Ms Brown at this stage?
For me, no, thank you.
Thank you. Councillor Sumner?
No, thank you.
Yeah,
Sure.
okay. Mr Charles-Lambert, if you'd like to present your case, sir.
Sir, yes, thank you. Thank you very much. So the reason I had no questions is that the approach and premise of the police responsible authority in this case is skewed and wrongly put to you. The focus is upon the very real and human tragedy that occurred on the night of the 25th of April, well, the early morning of the 25th of April, after a night out. One of those very tragic single punch incidents which have such tragic consequences. And of course, the licensing matters. And it's for you and your colleagues to effectively put aside, as difficult as it may be, the human story and focus on the licensing matters. And I'll firstly address you on the Section 182 guidance because given the way the case is put, it's important for us to remind ourselves of that. Firstly, we're told in paragraph 11.7 of the Section 182 guidance that general issues are not matters that are relevant for reviews. And what we are looking for is that there should be a positive tie or link by a causal connection to a particular premises. And in due course, I'll address this in two ways. Firstly, the sort of general issues in the area, and secondly, with the specifics. The next paragraph I'd like to draw your attention to is looking at paragraph 11.20, which tells us in the context of reviews, what we're looking for is to identify the cause and causes of concern and to identify remedial action where it's possible, of course, and then to take an appropriate and a proportionate response. Now, when we're looking at the causal connection, the positive tie, and the causes of concerns, naturally, paragraph 9.12 of the Section 182 guidance reminds us that the responsible authorities are going to be our expert source of advice, the police on policing matters and so on. But of course, they need to ensure that their evidence can withstand scrutiny. And so that reminds both us, the police and you, that when we have this human story presented to you and this human tragedy, nonetheless, we have to scrutinize that for the licensing concerns that arise. And when we're trying to work out what's the problem and what's the remedy, there are two final bits of the guidance that I'm going to refer to. Paragraph 2.21 of the guidance talks about the importance of personal responsibility of individuals under the law. So beyond the immediate area surrounding the premises, the conduct of individuals, whether it's going to their car, whether it's causing antisocial behavior themselves as a result of their drunkenness or not, is down to their personal responsibility. And finally, paragraph 14.13 reminds us that licensing law isn't really the primary mechanism to control general nuisance and antisocial behavior once they're away from individuals, though of course it is a key aspect of that control. And sir, I'm actually very grateful to the police for the careful way that they have presented their evidence. But insofar as this case is concerned, the relevant concern is that between the 12th of April and the 25th of April, there is evidence to demonstrate that there is a breach of the COVID opening regulations, and that has been accepted. Secondly, there is an acceptance that when faced with the initial question by PC Smart, the premises license holder, Mr. Shah, was evasive and misleading. And that was made clear on the subsequent occasion. That's recorded in your interim decision. And there is also a potential issue around SIA deployment, management, and engagement. What is also demonstrated in this case is that there is a concern over local general issues, particularly associated with the use of shisha and shisha lounges in the general area. Now that's made clear from the police evidence. It's mentioned at page 195 for the first time in the bundle of evidence. I'll just remind myself what it says. It's there that we first learn on page 195 that there are ongoing issues with other shisha lounges in the area. And in fact, what you may be familiar with is that the terrace lounge is on the first floor, and underneath there is an independent and separate premises which operates a shisha lounge. And quite often the identification with the terrace lounge and or the separate and independent shisha lounge is confused. So for example, in the evidence of the police, when they talk about complaints relating to shisha, shisha in cars, antisocial behavior, traffic issues, and parking issues, that all relates to the shisha on the ground floor and other surrounding shisha, because this premises does not make any provision of shisha. So I'm very surprised that given all this evidence, we've not actually winnowed through to actually work out what this premises does. Now, you'll see that confirmed in the police reports at page 214 as well, so 214, where again, we read, the location of the alleged assault is surrounded by shisha bars and other bars. So the relationship between these venues isn't clear. And you've also known from the information provided by Jitesh Halai that he started drinking at another venue before coming to the shisha lounge. And we know that the two females that have been referred to, they were in the car smoking shisha, which is something that seems to happen increasingly now as a result of COVID, but we're not told exactly where that shisha has been sourced and how it's been sourced. For completeness, page 221 looks at the way in which the assailant might have hid in another shisha bar. So it's really recognised by the police that there are all these venues in this way. And then perhaps the thing that gives us the most alarm and would have required a lot more scrutiny of the evidence is that at page 239, we're told, he told us the Terrace Lounge is above the Shisha Lounge. They are two separate businesses but share one entrance, and there is a shared camera for entrance. They also share security. So we already know that in this very sort of tight nexus, in the very direct vicinity, and that's the words used by Ms. Oliver for the Metropolitan Police, in the direct vicinity, there are other premises, including another premises, which is directly and intimately associated in the human tragedy that we're faced with considering today, that is described as the trigger event, which is not the subject of investigation. And it may be that it doesn't have a premises license. It may be that the police investigations are incomplete. It may be that the police picture is confused. But I doubt that, because the statement of PC Charlwood makes clear at page 43 that the area in and around Bideford Avenue in Perivale is home to a number of shisha bars, which have come to notice with increasing regularity. So it's incredibly disappointing that of the items identified by PC Smart, nearly half of them are dealing with shisha and with other venues that have no relationship to this premises. It provides a very sort of cloudy and unhelpful picture for you in terms of considering which of the premises. Equally, when we look at the trigger offence, what the police are effectively saying to you, if you are in any drinking establishment and on leaving that drinking establishment, you suffer some consequence unrelated to the establishment will be held responsible. So if I'm the victim of an opportunistic mugger outside the premises, at the local taxi rank, or nearby the premises, the fact that I've been drinking somewhere that night is down to the premises. It's not down to me being flashy with my new mobile phone and calling someone. It's not down to the muggers, it's down to the venue where you were drinking. And so the association that the police make with this undoubtedly serious incident is exaggerated in terms of its connection, and it is unhelpful. You might want to ask yourself this question in order to test this proposition that I'm putting to you. What can any drinking establishment, any hospitality venue do to prevent a mugging and assault away from the premises when a victim has left the premises, they've ended their night's entertainment, and they become a victim of crime? How can they? Well, the answer is very, very little, because we know from the Section 182 guidance and the way licensing works that the licensee's responsibility is to his premises, to the safety of people on premises. And in fact, you'll be familiar with the public safety objective, which makes it clear that public safety is all about the safety of people on the premises. Make sure they don't trip, make sure they don't fall, have enough drinking water, all these things. But if they trip and they're dehydrated away from you, they can't be your responsibility. And I appreciate that that may sound harsh, particularly given the consequences of this man's night out. But it's a reminder that we must focus upon the management of this particular premises. And so absolutely, I've observed that there were the breaches of the COVID regs. There shouldn't have been people on the premises. They shouldn't be eating. They shouldn't be dining in those groups. And they certainly shouldn't have been smoking roll-ups. That's acknowledged at this hearing and was acknowledged at the previous hearing. And of course, the premises have been suspended on the back of a very dire period as a real obvious deterrent and consequence. The second thing is the conversation with PC Smart. Entirely unhelpful, entirely foolish. However, sir, I would ask you against that to weigh this in. How many times in this hearing have you been here where we're talking about CCTV evidence? There was an electrical fault, it had broken down, the engineer was on its way, the disc ran out of room. In this case, the real relevant aspects of the police investigation are built entirely and exclusively upon the very full and frank disclosure made by Mr. Shah. I credit and also sympathize with PC Smart for having gone through all the CCTV. But what you can see is that she had full and frank disclosure of CCTV. It was clearly visible. It was usable, and she was able to put together a very clear narrative, down to the fact that she was able to identify from that narrative that there were roll-ups. In her experience, she seems to suggest that it might not be a legitimate roll-up. I don't know how she gets that from the context of a video, but either it goes to the quality of her policing or to the quality of the video. In any effect, what it says about the premises license holder and DPS is that he does work with the police outside of the panicked call post-COVID, where he realizes he's done wrong, and he knows he's done wrong because he is in engagement with the police, with the local authority around whether or not the area is substantially enclosed, and that is currently with architects. He has cooperated. So I think we can balance that with that. The next item is to do with the SIA relationship. These are premises in a very close proximity to each other. We've seen from the police case that there is one entrance, a CCTV camera that my client pays for and operates. However, when it comes to the SIA, what we know is that my client pays for them at the weekend, and the downstairs shisha lounge, which goes by various names. Sometimes it's shisha lounge, sometimes it's referred to as the smoke joint, and it's also known as Yasmin's at time. They sometimes pay for the security. The action of the security is really quite exemplary, because at this incident, we know that it was the off-duty security that were able to intervene. In fact, there were also 3 off-duty police officers enjoying shisha in the local area. That we know it was one of the SIAs from Park and Smoke that have actually identified the perpetrator. So far from being uncooperative, the whole security community that are in this area have in fact been very helpful, from accessing CCTV, talking with the police, and also you'll see here identifying the perpetrator, and that's at pages 252 to 254. I'll just remind myself of that. So you've got the discussion with one of the security. This is the security that is sometimes paid for by the premises, other times paid for by Park and Smoke. Park and Smoke is an entity that exists on Instagram, not on Facebook, and you can see the mischief in the name. And then it continues over the page, and it references at the bottom of the page another of the SIAs. I know this is being live streamed, so I won't mention any names out loud so as not to compromise any police investigation. But you can see there that he knows the guy who hit the victim. They were both into motorsports. They used to go to car meets. And of course, he's working with the police in order to identify that. So we're a considerable way in seeing that the SIA community, such as it's split, is engaged. So that is, if you will, my diagnosis, my view of the relevant causes of concern, trigger incident aside. And of course, when acting on limited information, you can well understand why the police might want to trigger a summary review. But the fact that once it's been triggered, of course, what we need to do is then step back, and the more information we get, the easier it is to step back and ask ourselves what the licensing issues are. Admitted breach of COVID, admitted false information, balanced by oversharing and the potential for the SIA relationship. So, sir, in my submission then, it's to look at what's the most proportionate response. You have here the initial denial coupled with the initial breaches of COVID regulations, but then you have full cooperation. You don't actually have any significant incidents that are linked to this premises that aren't related to the shisha premises, so they are of more than general application. So the premises license holder remains suitable. He remains suitable as a DPS. If, however, you want to add an extra layer of management, by all means introduce a new DPS. You've got the issue of SIA. It may be that you'd find it more helpful if each premises were responsible for their own SIA, particularly given what happens in the area of which my client is effectively a victim. He was there first. He established a very successful restaurant bar service. And what has happened is, in these sort of lots that are around this area, shisha has come in, it's become very popular. And on the back of the popularity of the Terrace Lounge, they've been able to operate in this way. So it may be that you require him to have SIA, particularly on the door, in order to ensure that there isn't a mixing of patrons. I can't suggest that you have him on the door, SIA on the door, acting as traffic wardens, because clearly the police are failing to deal with this long-standing issue of people being parked up in their cars, smoking shisha, causing a nuisance. And so to put that responsibility on a private SIA and a private operator would, in my view, just be wrong, but certainly in their own internal area. And finally, at most, you should be thinking of a very short suspension. They've already had a very short suspension in these circumstances. The effect of a short suspension in this climate cannot be overstated. And you also know that when you're thinking about proportionality and an appropriate response, you've got to think about the commercial impacts. And in fact, the local government secretary has written to local authorities on at least 2 occasions now, saying that when carrying out your functions, you are there to assist in the recovery of the hospitality industry, of which this is a part. So it's for that reason that also a short suspension ought to be considered, even though I submit that that's already been imposed. For this 1 day of breaching, they've already had a 3-week suspension as a first offence. So, sir, that I hope explains why I didn't challenge the police evidence. Firstly, because the focus was wrong. Certainly there was the trigger, but then we need to look at licensing offences. Secondly, they were dealing with the generality of general problems in the area and avoiding an examination of the direct concerns. So their initiative to act was correct, but then their diagnosis was wrong. and I hope I've corrected that diagnosis and supplied you with a prescription in terms of moving forward. So I'm available, Mr. Panchal is available, and indeed Mr. Shah is available to answer any questions that you or your colleagues may have. I'd urge you to dispose of this summary review in the way that I have suggested to you. Thank you very much.
Thank you, Mr. Charalambidis. Indeed, Brown from the premises, do you have any questions for Mr. Charalambidis?
Sorry, sir, was that directed at me?
Yes,
Sorry. I don't have any questions for Mr. Charalambidis, thank you.
Okay. Councillors?
I have no questions. Thank you, Chair.
I have no questions, Chair.
I wonder if it could be help for me, for Mr. Charalambidis, but you used 3 different words. You said that your client was defensive, evasive, and denied certain things. What could you give examples of what he was defensive about, evasive about, and what he denied?
Well, it's set out in the statement of PC Smart, and I'll just take you to the paragraph number because I think it's fair to look at those words. So the first time that PC Smart, I love a full bundle sometimes, and then I can't find anything, but it's here it is, paragraph 30.
Which page, please?
So it's page 35.
Yeah.
I'm
assuming we've got the same pagination.
Yeah, so it's completely obscured by the restrictions. But yeah, which is why if you find Kerry Smart's witness statement
at 455, yes, top of page. Top of page, point 25.
It's
Yes, exactly that page. Yes, and then it's paragraph 30.
Okay.
And so what we find there is that Mr. Shah is aware that he's having the conversations with environmental health. And so he has scaled back any of the outdoor smoking activities and instructed an architect in order to see how we can engage with the 50% rule. It's there that he's being evasive. And doesn't give a true picture of what was happening on the Saturday night, and that was admitted, and the admission of that is recorded, sir, in your decision notice of the 30th of April. I think it's in paragraph 2 of your reasoning. So it's there, but in contrast to that, what you see is the very full and frank disclosure, which enables the licensing officer, PC Smart, to give us the breakdown that she does in the way that she does.
Okay, that's useful. Thank you. Okay. Right. Just to be clear, you're suggesting that we dispose of the review, but you mentioned other things, other conditions that, not saying proportional, but what, could you just go over what you were suggesting there?
Well, it seems to be, looking at what has occurred, either you remove Mr. Shah as DPS, though of course he does remain the owner and the operator, but it may well be useful for there to be someone that he employs that can also say to him, hang on, sir, I know you're the boss, but these are the regs that are in place. And it may be that conversation, albeit that Mr. Shah could overrule them, acts as a useful additional measure. And the other was looking at the role of SIA, just to give some clarity around the separation. There is no SIA condition, but it may well be that the practice of having an SIA, particularly at the weekends or maybe at the evenings, would be useful. So there was an SIA that directly responds to the lounge is, and by that I mean the terrace lounge, not the downstairs shisha, howsoever it's called, and is answerable to the DPS and the premises license holder, so that when the police do come on to the scene and they want to speak to someone, there is someone that's responsible directly for those premises, and there aren't the excuses of, well, I'm off duty or I work for the other.
If the police were satisfied with the SIA provision, would that be acceptable to your client? I mean, if you said, your client said one SIA for a couple of hours and the police said, well, no, we want 2 SIA for several hours, that sort of negotiation, what would you think?
So what I'd say is, I think I took you to pages, let me just, 242 onwards, and I know there's some concern around one of the SIA not providing statements, but then at the same time there are many others that don't, and they've also been really helpful, to the extent that one of the SIAs, with a very memorable name, is able to ID the perpetrator. So in a very short space of time, all the SIAs in the area, whether they were given official statements or not, have spoken to the have spoken to the police and have actually genuinely assisted them. So I would say, for a premises like this, given its likely capacity, which is as a small restaurant, given that its outside area isn't being used for shisha because it's with the architects, the most reasonable and proportionate thing to do would be to have one SIA on the premises, probably from an evening. When we look at the times in this, we're really looking at 9-10 o'clock until half an hour after close. I don't know what my learned friend would have to say on behalf of the police, but that's where I think the balance would lie.
Okay, thank you very much. Yeah, obviously, yeah. Just bear with me while I get to my checklist. Okay, I have no more questions at this stage. Right, I would invite the applicant to sum up the day may, and then obviously the premises would have the right to respond to any points in their summing up. So, Ms. Oliver.
Thank you, sir. Can I say I'm surprised to hear the premises say that they don't serve shisha, because having done some research on their website, it certainly advertises the sale of shisha under the terrace lounge. And indeed, a shisha menu is provided on their website. And it's the understanding of PC Kerry Smart, I'll be correct if I'm wrong, that shisha is provided by the premises. So I would urge some caution before you disregard any of the CADs and crime reports and intelligence reports that you've been provided with, simply because they mention a shisha lounge or shisha provision as being the connecting factor to antisocial disorder, antisocial behaviour or disorder. I take the point that this does appear to be an area which is perhaps overcrowded, but certainly populous with other venues, some of which also sell shisha. But it's not always easy to distinguish when there has been antisocial behaviour or instances of disorder or instances of crime, which of those premises might have been most or predominantly or indeed exclusively associated with that behaviour or that misconduct. That's not the case, firstly, with the trigger event that you have before you, when there is a clear association and a lengthy association with this premises, nor is it the case with a number of the reports that you've been provided with. And I'm just going to give you a few examples of that. For example, the report that starts at page 77 and goes on to page 78 of the bundle, it states in that CAD reference, the male who had the big knife is in the terrace lounge now. You might feel that that's not a report that is talking in generic terms about problems associated with premises sharing shisha, but one that is specific to the terrace lounge. Similarly, at page 106 of the bundle, it's talking about a shisha lounge. It's called the terrace lounge. After 10 p.m, when they close, the customers go outside on the road or pavement and smoke the shisha there. Now, I understand, just for information, that the premises which is below the terrace lounge, just in case it was suggested that there might be confusion, is called Yasmin. So it's not the case that it has the same name as the premises that is before you. And similarly, then again, at page 122 of the bundle, it says at 8 p.m. today at Terrace Lounge in Perivale, there will be a gathering of 25 people from different households doing shisha and a party. This was advertised online. So I take my learned friend's argument to a point that, of course, you must be mindful that not everything that happens in this local area is laid at the door of this premises. That would be quite wrong and unfair, and that's not what we're saying. But quite properly, the crime reports and CADs and intelligence reports have been put before you because there does appear to be an association with this premises in certain instances and antisocial behaviour and disorder. And my learned friend says your task, and he's right, is to focus on the management of this premises. And if I can just perhaps sum up in 4 points why we say that is problematic in this case. Firstly, there shouldn't have been anybody on the premises on the 24th and 25th of April being allowed to become intoxicated or at all. That victim of this assault should not have even been there. Secondly, the premises shouldn't have been serving alcohol and allowing people, including the victim, to become substantially intoxicated. Thirdly, you have the opinion of the police officer in this case, at paragraph 46 of her statement, that it is often the effect of serious intoxication that makes people more vulnerable to involvement in crime and disorder once they leave the premises. And fourthly, we say that the premises ought to have cooperated more properly thereafter, not only Mr. Shah in terms of his cooperation with the police, and I take my learned friend's concessions on that point on board, but also we understand that no SIA member of security staff has provided an MD11 in support of this investigation subsequently. So those are the points.
What's an MD11?
I'm so sorry to use the jargon. That is a formal witness statement in pursuit of a criminal investigation. Thank you very much. Those are my submissions.
Sir, thank you very much. I'm grateful to my learned friend for acknowledging that the role of shisha in this area is overcrowded and populous, and it's not always easy to distinguish. And I think that's a correct statement by the police, particularly when you are in a hearing which must determine premises that are directly causally linked. So all of those wider shisha issues do fall by the wayside. I'm grateful to her for drawing your attention to the incident on the 7th of August of 2020. That is at page 77 and page 199. What you'll see there is that someone in the queue was causing a problem. It was dealt with by the security. The security called the police. On arriving, the police were able to confirm and corroborate with other members in the queue that it was the person causing the trouble. And so this is an example, firstly, of proper SIA management by the premises, proper cooperation by the SIA of the premises with the police, an example of good and effective management when people get rowdy and out of hand. In terms of the 29th of September and the online advertisement on the 16th of November, I'm instructed to categorically say that that is not to do with this premises. The premises identity is often used by other operators in the area to attract custom, but we say we are not associated with them. In any event, it's for the police to provide positive and direct proof of these links. They haven't given you the Facebook prints or any of those details to confirm that. So given that there is a failure of evidence for you to scrutinise and an acceptance that it's not easy to distinguish which is the relevant premises, I would ask you to put those two examples on the side, applying the police's own tests, as explained by Ms. Oliver. Finally, I do agree with my colleague that it is about the focus on the management. She makes 4 points. I'm very happy to agree with 3 of those. One, it's to do with whether persons should have been on the premises on the 24th of April. She's correct in that, and I've already made those admissions. Secondly, because of the nature of that operation, they shouldn't have been serving alcohol in the way that they did. And yes, absolutely, Mr. Shah ought to fully cooperate with the police. The point is, however, that he does, and he has done, particularly because he has provided the best evidence of those very breaches, far better than what we're finding, the police evidence itself, which has been demonstrated in my submission to be unreliable. I don't agree with the submission that just because I drink too much on a premises, the premises is going to be responsible for any mishaps, misadventures, or tragedies that occur to me once I leave. You know, we're not there to stop people drinking or to police the effects that people have when drinking. The effects of alcohol are notoriously difficult to assess and to consider. And it may be when you're sitting in the bar merrily drinking away, you have one impact, but then when you leave and you hit the fresh air, there may be an alternative impact. And I will add that if you've seen the photos, this advertises itself as a bar and a restaurant and a shisha. The shisha sales have been suspended pending the consultation with an architect and appropriate amendments that need to be made. So I'm not saying that we've never had shisha on the premises or that we don't want to have shisha on the premises, but that at the moment is very much in the future. So again, sir, I would urge you to take cognizance of the fact that you have already imposed a very short suspension in these very difficult circumstances, that you're able to impose a further short suspension in order to allow matters like a new DPS or SIA provision to be implemented, or you may just feel that removing the DPS, allowing for someone new to come in and an SIA provision might be appropriate. Sir, I thank you and your colleagues very much.
Okay. Unless the Heather, did you indicate that? No? No?
No.
Right, sorry, your camera came on. It was like you were queuing something. Unless the councillors have any further questions, clarification to either parties. Councillor Sumner? No. Yeah. Okay. That was and you can wave your hand as a no, Councillor Anand, or you could thank you. Something. Yeah. Thank you very much. So the procedure is we ask you to leave the room. I make the time now 15:40. By the time we leave the room, it will be. I would allow until 4:30 as a minimum, so 16:30. Do you believe that's realistic, Hattie, in order to in terms of writing up decisions as well, although you can, the full decision is in writing, is that correct? in 5 days.
Chair, can I just go back? Did you want to ask the police whether they wanted to address you in regards to what you've been invited by Mr. Chambliss before you end the hearing? And yes, it's a matter for you in terms of how long your discussions will take with regards to reaching a decision. And perhaps Ms. Harding can keep the parties informed if you give an indication, perhaps of half an hour to begin with, and if it takes longer, then so be it.
Okay, that's fine. So we'll say 16:30 with confidence, and we obviously reserve the right to take longer should we have to. So unless there's anything else, Cornelia will ask you, if you could leave the room, and if you don't leave the room, you'll be thrown out of the room. So great, thank you very much. See you at 16:30.
Chair?
Yes, sorry, Hattie. Well, yeah.
Sorry, did you just want to check with Miss Oliver whether she had any observations on?
Yeah, I mean, I've given her opportunity.
Indeed.
Yeah.
Just for the avoidance of doubt, we don't accept that the proposals given by the premises adequately meet the concerns that we've raised.
I'm grateful. Thank you.
Many thanks. Yeah. 16:30 at the earliest. Thank you very much.
Thanks, Chair.
Thank you.